Hello, I'm Hector MacQueen. I'm one of the Scottish Law Commissioners, and I'm the lead commissioner on the contract law project for the last 8.5 years.
Hello, I'm Charles Garland. I was the project manager at the Law Commission for the first six or so of those years until 2016.
We've worked together on the project, and further team managers have succeeded Charles. The report that we're publishing today is, as it were, the summation of all that work, apart from that which we've already reported on and it's been implemented in legislation already.
And why was there a need, do you feel, for a reform of contract law in Scotland?
Well, there was certainly a sense at the time of my appointment that people were choosing not to use Scots law to govern their contracts when Scots law would have seemed the obvious and natural choice. And the question therefore was there something wrong with Scots law and could we do anything about it?
And having whittled down all of the difficulties which were around, the report focuses on a number of topics. How do you see the current report as taking forward the modernisation and simplification of Scots law?
Well, I think the removal of the postal acceptance rule is probably both simplification and modernisation. It was introduced, this rule, in the early 19th century when post was really the only way remote parties could communicate with each other. And there had to be some rule as to when an acceptance that was posted took effect. And it was decided for various reasons that seemed good at the time that the answer should be when the acceptance was posted. Now, part of the basis for that was there was no alternative form of communication between these parties. But that hasn't been true for at least the last 100 years. We've had extraordinary developments in communications technology. And it really seemed to us that there was no reason to support privileging the postal acceptance anymore. And in any event, it was a bit of a pitfall or a trap for the unwary. It was fine for lawyers who knew the rule and they could exclude it in their contracts. But to the unwary business person, they might find themselves in contracts without any knowledge on their part of that, and all the consequences that might then flow from that. So it seemed to be a rule that was ripe for, as it were, removal, and the consultation confirmed that. And the effect is that it's no longer necessary to exclude the postal acceptance rule to avoid its potential consequences, which is common practice amongst lawyers. Instead, parties can, if they wish, under our proposed legislation, decide that they will, so to speak, create a postal acceptance rule for themselves. So I think there's clear simplification, clear modernisation there, and you're not going to get people who aren't aware of the postal acceptance rule suddenly finding themselves in a contract they knew nothing about. At the time it was actually formed, and I think that is a considerable simplification. You don't have to get into postal acceptances unless, for example, perhaps you wish to do so. So I think that is the way it should be in the modern world, rather than have a rule that takes people by surprise and means they're not in control of the situation with regard to whether or not they're in a contract.
That is an important rule to have as a general rule, which could be subject either to particular circumstances or to parties contracting out of, that offers and acceptances and other contractual notices take legal effect when they reach the intended party. And clearly with electronic communications, which will be the basis for quite a number of contractual dealings, the issue of automatic replies that people will set up on their email accounts, particularly business ones, will take centre stage perhaps now. How does the Commission envisage that working?
Well, what we thought was that the system would have to continue to be an objective one, in the sense that reaching is something that occurs when it ought to occur, as opposed to when it does occur. That's the sort of general principle. And what that is meant to do is to encourage people to be efficient in dealing with communications coming into them. In the electronic context, various technical issues arise, but generally speaking, I think the rule which is widely accepted is the one which we've included in our bill, which is that it reaches the addressee when it becomes reasonably accessible to that person, i.e. it's in your server, you can access it by switching on your email system, and it's taken that is what has happened. That is good business practice. I think the thing that we've managed to introduce, however, is that, again, this is all subject to considerations of reasonableness in all the circumstances, so that a person can guard itself against being caught out by an email that hasn't been read by providing, for example, an out-of-office message which indicates when that person next expects to be able to access their server, their inbox, and so on. And then it's no longer reasonable for the sender to assume that this is the communication is going to happen within a fairly short period of time after sending its own communication. So the whole point, really, of our law reform is not to create pitfalls and to remove pitfalls where that we know already exist, as with postal acceptance and other such rules.
And now that this report has been published, people can have a look at it on the website,
mm-hmm.
and obviously, if they're interested in getting more information than this video gives, can see that there.
Yep.
And the Commission now engages with the public in Twitter and LinkedIn and YouTube, obviously.
Yep, yep.
So the word is being spread.
Yes, I think so. And I hope people will pick these things up and find them of interest and engage with the Commission in other projects that it has going forward at the present time and in the future.